Good afternoon, everyone. Thank you for joining us on this somewhat impromptu webinar on COVID-19, hoping for the best while preparing insurers for the worst. I'm Scott Rybny of Morgan & Akin. I'm joined today by two of my partners, Wendy and Patricia. Say hi.
Hey, guys.
Hi, everyone.
I see we still have a number of people signing into the call here today. So just some brief preliminary items before we get into the real nuts and bolts of this presentation. First and foremost, I just want everybody to remember that we are part of PAMIC, and as such with this seminar, if there's any questions that relate to the antitrust policy, I would encourage you to take a look at that on PAMIC's website. Now, as it relates to this session today, it's going to be an hour long, and what our hope is for this is that this is going to be more of a round table, almost like a Thanksgiving dinner type presentation. We're here free of charge to hopefully answer as many questions as we can that you have regarding COVID-19, any possible, claim scenarios, coverage issues, you name it. Wendy is our go-to person on all things workers' compensation related. She does a bang-up job with the liability work. Patricia is, a phenomenal liability lawyer, so she can certainly handle any questions you have on that. And then many of you have seen my face before at a number of the PAMIC events. I do the coverage work and can talk a lot about those things. So we're going to kind of have hopefully a free-flowing discussion. All of us have talked to a number of different people in advance of this call today, and I know we've gotten some questions before that we're going to be addressing here on air as we talk, but I want to draw your attention to two features of this Zoom broadcast to the extent you have not used this before. There is a Q&A button on your computer screen. If you have a question for us, click on that, type the question, and we will get to it. If for whatever reason that's not working, there's also a chat feature on here as well. Feel free to type that in as well, and you make use of that. We are here for the next hour for you to talk about anything and everything related to COVID-19 that you think is going to be impacting your business here today. What I'm going to probably do is, Patricia has done a lot of these Zoom broadcasts before. She is like our broadcast specialist on this. So she may turn around and take over as kind of like the moderator to help speed this along, make sure that we don't really get off on too far of a tangent here and kind of keep us moving so we can address everything as quickly and as efficiently as possible. So with that being in mind, I'm going to turn this over to Trish right now, who I know has already a number of questions from people, and just to offer her thoughts on this.
So, hey guys, yes, we do a little bit of podcasting at the firm. So this is why I have this headset. I wasn't anticipating today, but that's why we have it. But yeah, so what we found, we're on day 10, really from when the pandemic hit, and people started to feel the effects in the insurance and claims world. And we tried, for the first couple of days, we tried to put out content, written content, blogs, video, podcasts to address your concerns. And what we found is that it's not a one size fits all. Everybody has specific questions unique to their claims or litigation management, whatever it may be. So we figured Q&A was the best way to give real value. So we really do want this to be a Q&A. I've compiled a list of questions that we've already gotten from clients, and we'll get started with that. But for the most part, I would love to see you drop a question or raise your hand. I understand there's a raise your hand feature here that if you don't want to type it out, you can speak it to all of us and we can answer it. I also am moderating because I'm a GL attorney. I handle premises and products and auto and trucking. And while trucking may be impacted by this, a lot of the other ones don't seem to, at least the clients that I've talked to, aren't really getting hit with that. So I probably have, between the three of us, the littlest value to offer. Between Wendy and Scott doing coverage, employment, and workers' comp. So that's why I'm going to throw them some questions. If you guys have follow-up questions to anything, or your own individual questions, again, drop it in the comments, or I'm sorry, the Q&A, and then the chat, and I will make sure that they get to them. If by chance we don't get to your question, we will record it and we will respond to it afterwards. We're going to try to keep this under an hour. All right, so the first question that we have is, one question we received is, how can a virus be considered a direct physical loss for coverage under an insurance policy's property coverages? I'll throw this one to you, Scott. How does that work?
And I was going to say that comes straight to me, and I'm glad this is one that we're hitting right out of the gates here, because looking at the people who are listening in right now, it's a very smart group of people who I know are following a lot of what's being written out there, and by a lot of attorneys, many of whom I know, and a lot of whom I consider to be very smart attorneys. The problem is that I think what's being said is not the full picture, and it's giving some carriers kind of a false sense of security in terms of the answer that's being spouted is, this is not a direct physical loss, period, end of story. There's our box. We don't need to do anything more. That I don't think is the correct approach for this, because it overlooks the fact that there are a number of states where they include loss of functionality within the definition of direct physical loss. This is what the courts look at it as. So one of the things that I equated this to recently was, what does ransomware attacks and COVID-19 have in common? And at first blush, you say really nothing. But we've learned from those other suits that in those ransomware attacks, whether there's a direct physical loss or not is something that's hotly litigated. And oftentimes the courts are saying you can have a direct physical loss be triggered under the policy where it's not physical damage itself. Some of the states that have that, New Jersey, for a lot of us right in our own backyard, is one that is very clear on that issue. Pennsylvania is somewhat muddy on it. There's some case law that says, no, it's not necessary. There's others that open up the door to the possibility of there being coverage for a loss of something's function. So the question then becomes, okay, is a virus considered direct physical loss? The answer is maybe, but you gotta look into it more to see what is impacted. And I say that in the terms of, you still have to do a complete investigation. Someone who says, my property was shut down because of COVID-19, well, did they actually have the virus in there? Was it tested for it? Was it not? These are all part of the claim process that has to still be looked at.
So how does an adjuster go about figuring out if the functionality is something they need to be worried about? Does that make sense?
It makes perfect sense. And it's a really good question, because one of the things now that's actually being bantered about is the costs of doing some of that testing. And you have some policyholders and their counsels pushing back saying, this isn't the type of testing that we should be required to do because of the burden of doing it. But what I would suggest for the adjusters out there, and recommendations for the carriers, are when you have the claims in and there's a claim for the exposure, whether it's a cleanup cost for a building, a house, a commercial property, costs that can be pretty large regardless of size, the business interruption loss, I would treat those claims in the same way that you would treat, say, another contamination case, whether it's a mold case, whether it's some type of toxic fumes that are in a property. You've got to identify the source of it. How did it get in there, number one? And then number two, is it even in there? Now, that brings up a whole host of other potential coverage issues in terms of after the fact remediation. We can talk about those later, but go to your bank of personnel where you say, here's who we would use if we're going to go out there and look at a property. But first and foremost, beforehand, I would be formulating a number of questions for the adjuster to the insured in terms of, okay, has the property been mitigated? If so, who did the mitigation? And look into those companies, get whatever information you can from them, because maybe they've already done testing and can give you the information right out of the gates.
Anybody else have any other questions or comments on the direct physical loss? I seem to see that everywhere on the news blogs that I look at. That seems to be the heart of the coverage issues, is the direct physical loss, and whether this is, what's going on right now implicates that. Anybody have any questions on that?
Let me just, if I can just, before we leave this topic, run through, because I know a lot of the people on the phone, and this is PAMIC, and even though it's Pennsylvania centric, a lot of you write policies in other states. Let me just kind of run through with you right now a list of the other states that consider loss of something's function. And by loss of function, we're talking about the ability to use the property for its intended purpose, that include that within the direct physical loss requirement. Those are Arizona, Tennessee, Maryland, New Jersey, North Dakota, California, New York, and Colorado, just to name a couple of them there.
And if anybody wants that list repeated, let us know, and we can either repeat it or we can send you an email, whatever works best. So I'm going to flip back and forth between comp, employment, and coverage. Again, just drop your comment if you want us to follow up with anything. But my next is really a comp question for Wendy. Can employers ask employees to disclose whether they've been exposed to COVID-19 or ask other related health questions?
So this has been a very hot topic. I get questions about this every day. And a couple weeks ago, I actually presented to a group in New York, and I talked about the ADA Act. And under the ADA Act, employers generally can inquire into medical conditions that are not job related. But as you've seen in the last 10 days, how everything has changed, and there's been a shift where there has been, what's the balance of privacy? And there's, what can an employer ask an employee in terms of their medical health in relation to COVID-19 in the name of public safety. So what you're seeing now is that in the name of public safety, employers are distributing health check survey. I had a person call me today, their place of employment. Actually, before the employees come and can enter the building, they have head scanners that take the temperature of the employees. They are allowed to ask employees if they've traveled outside of the country in the last 30 days. Have they come into contact with anybody that has been diagnosed with COVID-19? So again, there's just this fine balancing act. When you look to privacy laws, there's really kind of an open area here. And there's been a lot of reference and examples going back to 9/11 as to what people can and can't ask in the name of public safety. And some people, especially in the medical field, look to the U.S. Health Insurance Portability and Accountability Act. There's a portion in that act that says that healthcare providers have to share information with public health officials. So, you think about all the healthcare workers out there right now that are being exposed to patients that have COVID-19. But this has gone even far beyond that, as to what, businesses are staying open and the employees and even visitors that are coming into their business. So you think about just what they can ask employees, they even can ask visitors these similar questions about their health before they can come in. If anybody's been to the doctor recently, but if they make a doctor's appointment, it's very common right now for the receptionist or the intake person to ask you whether or not where you've traveled in the last 30 days. Do you have shortness of breath? Are you experiencing any flu-like symptoms? I know, Trish, you were coughing earlier. I said, you don't want to cough on this webinar.
And I just did too. And I'm not COVID positive yet. Not that I know of.
But now there's this fear, and you have to look at, you have to think that employers now, again, it's not that they're asking non-job related, medical health questions, but for public safety reasons, they have to ask these questions.
Are there certain industries that are going to be given a pass that to say, look, I need to ask you those questions? And are there certain industries, employment industries, where they shouldn't be asking? Or is it across the board, every industry is allowed to ask?
So it's, like I said, it's been mostly with the high risk, when you ask who is the highest risk here, you have healthcare workers, you have airline and travel personnel, laboratory workers, emergency responders. But as you look at the list of what's been life essential businesses that have been kept open, even within the state of Pennsylvania, you have paint companies that are staying open because they need to provide coatings for the walls for these makeshift hospitals that are popping up, or healthcare facilities. As of Saturday, I saw a clip on the news that there were some retail stores that were staying open. So those are types of businesses that are having to deal with any type of the public, have the right to ask those type of questions.
Are they,
Wendy, can I just jump in here real quick? Because I know that, with some of the people on this call, probably almost all of them, they're going to say, well, we think we fall into that kind of high risk category because we've got to go out and look at people's homes and, if they had a fire or a loss. Can an adjuster, before they go into an insured's home, do you think, ask a homeowner, hey, have you been in contact with anyone with COVID-19? Kind of the same questions that these employers seem to be allowed to ask their employees?
Yes. And that's what I'm saying. It's that fine line that they're drawing right now between public safety. You can't ask certain health questions, you can't get really personal, but certain questions, have you been in contact with somebody that has been diagnosed with COVID-19? Have you had flu-like symptoms? We're at a pandemic here right now, so those questions like that have been allowed. Again, you'd have seen, I just saw a company today that was putting out health check surveys, requesting any of these employees to fill these out before they were allowed to come back to work.
Well, let me pivot to another topic then. If an employee is afraid of exposure, could they seek a mental workers' compensation injury?
So that's an interesting area of law right now. And in generally, and I'm going to talk specifically, I guess, because Pennsylvania right now, that what we call, if somebody's afraid of having to go to work and having to deal with the public, right? If they were to bring a claim saying that they were disabled, they could not go to work because of the fear that they have of being exposed. It's a pretty hard claim, a valid claim. If a adjuster called me and asked me what I would tell them, I'd say, I would deny the claim. Just on the face, because they're called mental claims, and they're very hard to prove. The claimant or the injured worker has to prove an objective abnormal working condition. But that's sort of where we're wading into uncharted territory here as to, could making a worker come into work, even if it's a life essential business, or what they consider a life essential business, continue to work, such as an airline worker, is that subjecting them to abnormal work conditions because how contagious the COVID-19 virus is at this time? And that's where you might start seeing the claims come out later. I don't know if it just having the fear itself, it's not, because they still have to prove that there is a disability, that they're disabled from working. But in case law out there, for people who wanted some case law sightings, you can look to the Newcastle case, Newcastle versus Workers' Compensation Appeal Board. But they talk about, it's called the kissing case. Somebody at work kissed their coworker on the cheek, had a contagious infectious virus, and killed the employee. And that was considered a valid work injury. But again, when you just talk from a mental standpoint, just the fear itself, they have to show that objective abnormal working condition.
And with that objective abnormal working condition, that would be really evidence, right? So if 90% of their coworkers are getting it, that would be like a piece of data that would go to support their claim. Is that kind of what you're talking about?
Yes, like if they, look at it on the flip side, we're defense attorneys. Is it an abnormal working environment when we're all dealing with this, that we, that they're all the airline workers, we're all exposing ourselves to the same conditions, but we have to continue our services. This is a life business.
So let me pivot back to coverage. And again, if you guys have questions, feel free to drop them in. I'm just going to keep asking until I see another question pop up. But so there are a lot of questions about business interruption losses arising out of the policy's civil authority coverage. We see that a lot. What are some of the issues insurers need to be focused on? Scott.
It's a great area, and it covers, or a great question. It covers a lot of ground there. And I've got to say, the way our state is set up right now, it's making it terribly confusing, and it's going to make these business interruption type claims that much more complicated. But let's take it piece by piece based on the typical policy wording here, and hopefully this provides some clarity. Number one question is, okay, what is the order or a civil authority? And the way the courts in Pennsylvania have decreed that is, it doesn't necessarily have to be a written order. It can be a verbal directive from someone within a position of authority in the government. So when you had, for example, Governor Wolf talking about, people needing to stay at home, one could argue that that was the equivalent of a civil authority order. Now, here's where it starts to get real tricky. Okay, we talk about life-sustaining businesses. And as I was reading through the list, and there's actually a list on the governor's website of industries that can stay open and those that cannot stay open. I've learned that what I think I need to sustain my life and my family's is much different than what apparently the state of Pennsylvania thinks. There are right now, as of last count, 169 different categories of businesses that are accepted from the closure order. Give you a couple of examples here. And again, you go back to things you would need on a desert island. Apparently, landscaping companies to mow your yard are allowed to operate in this time because they are considered a life-sustaining entity. Dry cleaners are allowed to stay open during this crisis. So it's not what you would normally think. The paint suppliers providing the paint for the makeshift hospitals, the medical providers, the supermarkets, there's a lot of industries that are open there. So when we're talking about a business interruption claim and someone saying, hey, I had to shut my business down because the state told me to, step number one for any adjuster should be to go and cross-reference that back against the list to say, okay, did you shut down because you were really ordered to shut down? Maybe they heard some misinformation being reported from the news, from social media, wherever it was, just, their neighbors saying, did you hear everything is shut down? We have to hunker down here. But you need to find that out first, because if they're not on the list of businesses that should be closing, then they're going to have a much tougher time invoking that coverage to say that they were required to shut down. This is also one of the clarities in Pennsylvania. And again, the thing I want to stress here is that, while this virus may be new, many of these coverage issues are not. They've been addressed by our courts and many other courts in different situations. For example, following 9/11, when the airports were closed, hotels suffered a loss of revenue. They sought coverage under this civil authority provision. And many of the courts uniformly said, no, if you're tangential to that and just kind of the byproduct of it, you're not in that area or you weren't told to close, the coverage is not available for you. Okay. In Pennsylvania, we've got similar cases, and I've got the case sites if anybody wants them afterwards. I'm not going to, bore you with all of them now, but I certainly can. All I'll tell you is one of them comes out of Lackawanna County back in 1957 in a hurricane, where the court said, look, if you're closing down to prevent, at that point it was the threat of a fire, that's not civil authority coverage. It doesn't trigger it. Well, you can draw some parallels here to say, okay, if you shut down voluntarily, not because you were told to, and to kind of prevent the spread of something, well, it makes it tougher to do. But again, you have to be asking the right questions. So again, number one, look to the website, see, are they on that list? Number two, are they, how are they supposedly impacted by this? Okay, are they in a county that had to shut down? The harder question is, what happens when you're in that business that's supposed to be shut down, but you're not in the county that's supposed to be shut down? Okay, these are much tougher questions, but that's where you really need to be getting into the fact specifics of the business itself. Okay, where did your revenue come from? Are you on that list? How many people did you have to close down, and for what time period? If you find out that the business closed 3 weeks before any orders went into effect, well, that's going to have an impact on the coverage analysis.
Well, let me follow up to that. So let me throw a hypothetical to you. Say the governor issues that order shutting down on all non-essential businesses, and you're a non-essential business. So you shut down pursuant to that order. Does that automatically invoke the civil authority coverage, or are there additional steps to look at after that?
I think that there's in terms of it automatically invoking it, I think it certainly weighs in the insured's favor. If you're in that zone and you're told you can't operate your business, you need to shut down. The courts are going to look at that and say, okay, we've got the order from the civil authority. The question is then going to turn on, because a lot of these provisions actually require as well, it's stemming from some type of property damage. And there's a great debate going on right now among lawyers, and a lot of it's stemming from this case in New Orleans, one of the first ones that was filed, in terms of, does a virus cause property damage? Remember that discussion we had at the outset about loss of functionality, or even just beyond that, can the virus somehow cause some type of physical alteration to the structure to make it uninhabitable? And, I think it's going to be a tough argument for the carrier to be in a court saying, okay, we're in an area where the business was shut down, ordered to be shut down. We want coverage under this, the specific civil authority coverage. And here's, what I'll call some legal wranglings to try and get through that. Is it possible? Sure, I guess anything's possible, but it's a hard road to sow.
How much does I assume that, if a claim is submitted and then denied, there's a lawsuit that follows. Let's just make that assumption for now. Does it matter? Venues are different within Pennsylvania. File it in Philadelphia, it's very different than filing in Delaware County or Luzerne County or even Allegheny County to some extent. How are you going to see the liberal versus conservative judges coming out with opposing opinions? Do you anticipate stuff like that happening?
Sure. I think that's inevitable in just about any litigation. The only thing I would caution about, and again, this is where I kind of go back to the investigative part, because where some of the law that's made it harder on us on the defense side for coverage is where the investigations aren't necessarily complete, or there are, cases being argued by people who may not necessarily understand the coverages by the way we do here. So it's certainly possible.
All right. Well, let me interrupt you because we got our first question. Yay. I'm
right.
So
and I just saw that pop up as well. So I'm sorry if I got a little distracted there.
That's all right. So I'll read it out loud. Can you give an update on the issue of business interruption insurance from a federal perspective versus a state perspective? Do you see the different levels of courts doing different things?
Well, here's how I'm going to answer. I'll answer that one this way. I think from the carriers need to be more concerned about the federal courts and how they rule on these coverage issues, because in my experience, the federal judiciary has been more inclined to give deference to other federal judges when they are making their decisions. And they'll look to judges, and that's why we keep track of where the cases are coming down from. The New Orleans case, how that could ultimately play out, because that will definitely have more of an impact up here. If you're in some jurisdictions such as, the Middle District of Pennsylvania, well, a judge there may rule differently on this than, say, a judge from Center County, Pennsylvania. Okay. If you're a judge in Philadelphia County, one where everything is shut down, that's going to be different than a judge in a different county that maybe isn't necessarily shut down the way we are here.
All right, another question. How is the legal community handling notary and wet signature requirements on legal filings?
I can answer this because I've been getting this question multiple times this week. So there are certain documents, obviously, that have to be notarized. At this point, that there used to be, as of Monday, I found a company that was doing mobilized notaries. So if you had to have a time-sensitive document signed, there were these mobile notaries going around. That has been curbed because of the interaction with the public and the virus spread. So if there is one still operating, it's very few and far between. So how I've been doing this right now is I've been telling clients to send the documents notarized, advising due to the coronavirus. As soon as this comes out, for the time purposes, we're sending out this form. We will get it notarized as soon as possible and resend it to preserve that time piece. And the reason why you need that is because the notary has to see you live signing that document. And that's because people have asked, well, can't you, sign it and then FedEx it to a notary? And I said, no, you can't do that because that kind of defeats the purpose of what a notary is. Actually, for workers' compensation in Pennsylvania, there is a document called compromise and release. So that's a settlement document. And on the back page of the certification page, you either need to notarize it or you have to have two witnesses watch you sign the document. And they have gotten authority from the state to allow to proceed with compromise and releases with just the signatures, no witness signatures, and no notarization for right now.
And I'll add to that too, for the wet signatures, at least in our legal practice, for the counties and judges that require them pre-pandemic, we're reaching out to them to see if we can do electronic signatures, and all of them so far have said yes, and they're giving us a grace period on that. I don't know if that applies to the question. The other thing I want to note is watching the real estate community. New York just passed a bill allowing notaries. I don't know how that operates. I just read about it the other day. I think if the real estate, if that grows and other states adopt that for real estate agents and allowing them to do e-notarize things, you may see that capability leak over into the legal world too. So something to keep an eye on. All right, so I'll go back to coverage for this one, my next question. Currently, Governor Wolf's order is limited in scope to 7 counties in Pennsylvania. I think it might be up by now, but can an insured in a county not impacted by that order submit a business interruption claim due to a decline in customers who usually travel from one of those impacted counties? So especially the tourism industry, right? If you're in a county not in a shutdown, but your industry is tourism, you're certainly going to be impacted by customers not coming. And can those businesses submit a business interruption claim?
Sure, and the answer to that, based on our cases right now, and there's case law in Pennsylvania that deals with very similar topics to this, appears to be no, that if you're not in that area that's affected, then it's going to be harder for you to be able to sustain the business income claim. And, for some of us in the Northeast may remember, probably about Lord, 10 years ago, then the Shawnee Ski Resort was shut down because a bridge was out. And it restricted access to the resort, the main way in. There was another way to get in, but the main thoroughfare was just out because the state was doing work on it. Well, Shawnee tried to bring a lawsuit against its insurance carrier saying, hey, we've had a loss in business because the locality or the state was working on this bridge and people couldn't get to our resort. And the court, it was a middle district opinion, said, no, merely because the state hindered access to the property without completely prohibiting access to it, it doesn't trigger coverage under the civil authority provision. And that decision, if you look in a number of different jurisdictions and states, appears to be in line with the way courts are looking at that issue. But again, I would want to just absolutely make sure that whatever order is in effect, because as we've learned just over from last Friday to today, what's on the list, what counties are on this list of closures seems to be changing from day to day to hour by hour. So you want to make sure that when you're doing your claim analysis, and this is where I think it's going to be very important as well, that the adjusters not just look at kind of what the final list was, but also go back and see, okay, if you can, what the list was on the certain date that the insured is claiming they had to be shut down by or they couldn't work by.
So let me ask this next question, and if there's any follow-up questions, again, Q&A. Wendy, are businesses liable by staying open and potentially exposing employees to the virus?
So this is a multiple question. It covers multiple fields of employment, workers' compensation, and even a general liability. So under workers' compensation, in fact, there's a new law that just came out. I got notice right before we got on this webinar that the workers' compensation insurance organization actually put in a new code for those that fill out first reports of injury. Under workers' comp, there's a new cause code it's code 83 for pandemic, and there's a new nature code of 83 for COVID-19. That goes into effect for all COVID-19 claims that will be made effective from December 2019 or later, and this law will go into full effect April 1st of this year. So that's huge because now you got the workers' compensation viewing COVID as could be considered a work injury. Because generally workers' compensation covers occupational diseases, not ordinary diseases of life. But when I was looking at this a couple weeks ago, you talk about, employers are staying open, and these employees will come out with claims saying, well, hey, you're making me work. Even though you know that it's a life essential business, but there's this fear out there that I could be exposed. So the first thought is, well, could it be a workers' compensation claim if the employee gets COVID-19, test positive? Then if it's not, let's say the claim's denied because it's not an occupational disease, you take it into the general liability realm. And there's this question out there as to whether or not a company, by staying open, is failing to exercise a reasonable care in guarding against the risk of exposure. Scott, you and I were talking about negligence per se. We can get more into that. But, whether these employers keeping their businesses open and exposing employees, even visitors coming in, the claims that could come out of it, we don't know that yet. But we're getting prepared. The laws, I think, are changing daily as we see them as to whether or not these will be compensable claims under a workers' compensation setting, a GL setting, and even possibly an employment setting. Just had a call today that somebody was terminated, called out sick for fear of being exposed to the COVID-19 virus.
Right, and one of the things Wendy and I were talking about before, and I kind of threw this out there, is really with respect to like the homeowners insurance arena. And, I'm looking at a situation here. I'm wondering, geez, okay, what happens if you have, people who have a cleaning service come out to their house, or the nanny that comes out to their house to watch the kids because both parents, let's say, are in the healthcare field. And if one of them is exposed to COVID-19, then let's kind of, follow the chain down the trail here to our worst scenario is, okay, then the cleaning person gets, infected with the virus. They go to clean the next house, and the next house happens to be a 60-year-old who has immunity issues. 60-year-old contracts the virus and dies. Now, okay, is the homeowner then, potentially liable in negligence because they had the cleaning person come out to their house or the nanny and didn't stop that service? And let's assume it's in an area where Governor Wolf says this is a stay-at-home area. You have to stay at home. That's where I was thinking, geez, okay, you've got the negligence per se out there. Would that apply to a situation like this? And then, if you get beyond that, and then we start getting into carriers' worst fears, and that is, okay, you've got a negligence per se out there. Now you're talking really causation and damages. Are we now going to be faced with potential excess verdict scenarios? Very realistic possibilities, and not so remote, so to speak.
And I'll speak as the GL attorney primarily. Is I think this really will come down to creative lawyering. I'm sure a number of people on this call see those complaints that come in, and you're like, how the hell did they put those facts and legal arguments on a piece of paper? Because they are getting creative. And I think the plaintiff's bar will get very creative on the GL side to figure out how they can compensate their clients who contracted COVID, especially if there's death from that. So I would look out for the creative. I've seen some wacky things in my career on the GL side, and I primarily practice in Philadelphia, which is, judges let things pass, preliminary phases. You are looking at these wacky creative lawyered cases through trial. So I wouldn't put anything past anybody, even if there's massive causation arguments there. I would be a year or so down the line, I would be prepared for more of a spike in GL claims versus what we're kind of seeing now is the spike in coverage and comp stuff. It's the more immediate, I think, impacted law area. But I think, once that passes, you're going to start to see the GL claims spike. All right, let's move back to coverage. Scott, this one's for you. Do you have any best practice recommendations for insurers for inspecting properties?
No, absolutely. And that's a great question. And I mean, let's face it, nobody wants to put themselves in harm's way. It doesn't matter whether it's COVID-19, whether it's the unstable property. You want to make sure that you and your employees are as safe as possible, but you're also getting the job done that you need to. And I think part of what Wendy had said before certainly applies here is that, before you go out to inspect a property, you would be well within your right to ask an insured if anybody in their property has been exposed to COVID-19, okay, had any contact with that. I will also say that, I've been on inspections before, not so distant, where people have done them by video. And literally you've had an insured or a public adjuster, because he wants to have somebody else on looking at it, literally walking around the house with kind of giving directions. Say, okay, we're in the dining room now. Okay, where's, the damage here? Okay, it's up here. And then they move the phone up that way or this way to see everything they can. The technology is there to certainly take advantage of it if you want to go that way. I also think that given the circumstances here, and in terms of the gravity with which the state and federal governments have approached COVID-19, if it's not a life-threatening situation and you can push off a property inspection, let's say we're under the 2-week quarantine, or if it's pushed out another week, to say, okay, send a reservation of rights letter, let the insured know we're going to get there as soon as we can. Here's what we're being told by the governments. we can't get out and inspect your property just yet. If something changes, let us know. Here's maybe other ways that we can go about getting the information. It's not to say to punt the claim forever, and certainly don't lose sight of it. But again, it's something that makes sure that you and your staff are safe first and foremost. And I think if anybody were to call, you into court, I would have no problem standing in front of just about any jury in this state or in any state and saying, look, why didn't you get out and inspect the property within the first, 21 days? Okay, because 20 of those days, the governor had a stay-at-home order, and they were really trying to contain this virus. Were we being reasonable? We were. And here's what other steps and accommodations we tried to make in the meantime as well. Now, it may also mean you have to visit ALE issues if it's a type of claim that warrants that. But stay on top of it and do what you can, but keep yourself safe first and foremost. Second, right behind that, you got to remember the reservation of rights letters.
So then that kind of segues right into my next question, which is what about best practice recommendations for coverage claims handling? What advice do you have in this current environment?
I think with the coverage claims handling, it's important that you treat these issues as the serious issue they are. Anticipate a number of claims, and if you're not seeing them now, be proactive. Let's just start out of the gates and ask the question, number one, with potential new claims. Do you have the staff, and that could be in-house or outside staff, able to handle an influx of claims and any issues that could arise? And that goes from forensic accountants. I hate to say lawyers because I don't want to seem like I'm self-promoting here, but we also play an important role in that process. Independent adjusters if they're needed. And does everybody kind of know the types of questions they need to be asking? Business interruption claims can be very complex claims. If you're talking a contamination case, which is really at the heart what these claims are going to be, is contamination type claims. Are you prepared to handle an influx of claims like that? Beyond that, let's talk about the claims you have already. Because while we're all making adjustments here to work in different locations, I mean, you could see where the three of us are right now. You can't let those slide as well. And if there's going to be a delay in a claim payment or in any aspect of a claim that's going on, make sure you're paying tight attention to those diaries and sending the follow-up communications to the insured. Remember, the insurance regulations can be your friend here. We often don't think of them that way, but they give you the ability, if a claim is going to go on for a certain period of time, to explain why. Sending a letter, an email, something that communicates to the insured in a document. A phone call is great, but phone calls can be challenged later on. I know we've got two questions here, so I'm just going to kind of deviate from that right now because I think I hit those, and these two questions look more important.
Yeah, and I'll just add real quick to that. I would also pay attention to what's going on in other states. That Louisiana case that's making its way through the courts. The reality is if you are dealing with a litigation with a judge that doesn't know coverage, they're going to be looking for guidance, and they may be looking at what judges are doing and the opinions. So follow the business interruption claims and coverage claims that are coming out in other states. There may be different law, but I think there's going to be a lot of borrowing rationale and reasoning across state lines. So you can get a handle mentally on how it's rolling is probably a good thing. All right, first question. Does an employee have an obligation to disclose a health condition that makes them more susceptible to the COVID virus? Wendy, I'll give this to you.
So this person's going to like this answer. It depends. Depends on the kind of employee you are. So again, then this has not changed. Under the ADA, employers cannot inquire into medical conditions that are not job related. That's still the law. However, right now with healthcare workers, again, these high risk workers, airline workers, they're giving them health surveys, health check surveys, asking them about certain health conditions. So that's the difference. Like, do they have an obligation to disclose health conditions? Somebody just asked you a blanket question like that, I'd ask why. But as of right now, when you have these health, if you're a health worker and they give you a health survey or they ask you these pertinent questions, yes, you would have to disclose if there is something that might make you more, like if you have, I've had somebody that said that they had to disclose they had a diabetic condition. They weren't really sure how that condition makes them quite open to COVID-19, but they did disclose that. Also, just to make, this is just a little bit outside of this question, OSHA has a lot of information on their site right now, but anybody that has been diagnosed with COVID-19, you are to report immediately to your employer that you have that diagnosis. You are obligated under law.
All right, next question, and it's funny because Wendy just had a vehicle inspection on Monday that shut down. I know it's not a vehicle inspection, but insurers are starting to experience accessibility problems at body shops, driving up storage costs. What advice do you have for insurers experience difficulty in accessing vehicles for appraisals? I'll throw either one of you, Scott or Wendy, want to take that?
I will go and I'll deal with that one in part here right now. What I can tell you is that if you look at the governor's website in terms of what shops are closed, okay, and we look at the motor vehicle and parts dealers, automobile dealers are closed, other motor vehicle dealers are closed, automotive parts, accessories, and tire stores are exempt from that. So what I would want to know is if the body shop is not allowing you to inspect the car, number one, are they open? Because again, we've seen this type of issue in Philadelphia repeatedly in the past where they will try and delay an inspection to drive up the costs. And if they're open and they're not subject to these close orders, then I think you've got a reasonable basis to go and tell them that, you know, you want to get the vehicle inspected by such a date, or you're not going to be liable according to the cost based on the fact that they're supposed to be open, you know, or at least they're not ordered to be shut down. Let me put it that way. Okay. Beyond that, think of alternative ways that you can go about inspecting the vehicle and maybe triage certain parts of them. All right. If it's less damage, you know, we're not talking frame damage, then, you know, maybe that's something you can do by way of a video call where they're going around and pointing out what things are at issue here to try and keep the claim going. Obviously, the more serious the accident, where you're getting into the need to inspect frames and things like that, may not be conducive for it, but I'd say, you know, take it on a case-by-case basis as well.
I was just saying, in my case on Monday, it was a motor vehicle accident death case. I had to wait for access to have the vehicle allowed for me to view the deceased vehicle. And it was the police department that actually didn't let me come out. They originally had set it up where I would just be, they were going to have the car pulled out of the storage, brought to the police department's parking lot so I could just take pictures of it. And my expert didn't need to go for this. I checked with them ahead of time. And it turned out that the police department would not let me do that. But we did talk about the storage costs and the ongoing storage costs until I would be able to go out and do that. And they have actually made a deal with the police department not to drive up the storage costs on this. And that's just in my particular case.
All right, this is a great Scott, did you want to add anything?
No, I was
Okay.
no, I was just going to read the next question out here, but go ahead. You're doing a better job than I could.
I can read, that's for sure. So the next question is a great question, and it's not just limited to Delaware. The entire New Jersey is like this. I'm in New Jersey right now, and many counties in Pennsylvania on that. So I'll expand it to say, you know, in the states where bars and restaurants that sell food are allowed to sell food and alcohol for takeout only, what is your opinion whether they have a business interruption claim?
And what I'm going to say is there's really two parts to this. Number one is it a physical, like, do they have the ability to say, yep, we can have a claim to begin with? And let's exclude the valuation part of that for a moment, but do they have the business interruption claim aspect of it? And with a lot of those areas, I would, you know, I'm familiar with Delaware. Some of the areas where I've gone down to, and, you know, I know that they're in the shelter in place. And here's the alternate way of looking at this. Okay, I've done a lot of focusing in on the business itself. But what happens when the state says, okay, your customers can't go and eat in the restaurant, or they put that limited type of qualification on you. You can only sell food or alcohol, but you can't for takeout, but you can't have people sitting in there. We have the same thing going on in Pennsylvania right now. And I would say it's a unique situation, but one that does fit within the civil authority type coverage, because you could look at it, and I think this is a reasonable way to look at it. The government is shutting down a specific aspect of your business. You know, you can't operate this particular way. You can only operate it in this alternative way. So I think it technically would fall within what the courts have defined as a business interruption type scenario. Your valuation question for that's going to take a lot of legwork, because you're going to have to try and get into how much of the insured's business is derived from takeout versus how much is derived from the eat-in dining portions of it. And a lot of the smaller restaurants, at least when I've dealt with business interruption claims, they don't keep track of, you know, one versus the other. They just have their numbers at the end of the page on the bottom line there. It doesn't make it monumental. It just makes it that much more difficult, and may require you to go back more than what we typically consider 3 years of looking into the numbers to see how much is, because for all you know, this business may get 80% of their revenue from takeout. You know, if you're talking a pizza place down in Millsboro, Delaware, where they might have seating for, let's say, 20, but most of their revenue is on takeout, but they're trying to say, well, geez, you know what, we've had a drop because we can't seat people in here. Well, you got to get into that in a lot more detail. And it may be one where you need to pull a corporate representative in for an examination under oath.
So we have maybe a minute or two left. I want to get this last question in. Your thoughts on coverage denials and the alternative: primary denial based on exclusion, secondary denial, and the alternative based on no direct physical loss.
And I'll answer that rather simply this way. If you're going to deny a claim on something, I don't like and maybe this is just the way the question is worded, an alternative, meaning that, okay, if I don't win on exclusion number 1, then here's exclusion number 2. Lawyers plead in the alternative. The courts allow us to do that. I think if you're going to deny a claim, everything you rely upon in that denial letter and cite should be a ground on its own to deny the claim. It's not, if not 1, then 2. It should be, okay, here's all the reasons why this claim is just not covered. Oh.
Sorry, I got muted for a second. Great advice. I'll wrap this up. If you guys have any other questions, you can find our contact information on the website or on this invite. Happy to answer anything independently. But I feel for you guys. We all feel for you guys. I know you're dealing with some tough questions, and I think it's just going to get tougher as more plaintiffs' counsels and claimants' counsels get on board with the type of claims they want to file. But we wish you guys all the best, and let us know if you need any questions or help.
Thank you, everybody. Stay safe.
Thank you very much.